Hi everyone, today is October 12, 2012 and I am your host Jane. Today's topic is Worker Adjustment and Retraining Notification Act WARN Act. So Mr. President, what is Worker Adjustment and Retraining Notification Act WARN Act?
The Worker Adjustment and Retraining Notification Act, WARN Act, is a United States labor law which protects employees, their families, and communities. By requiring most employers with 100 or more employees to provide 60 calendar day advance notification of plant closings and mass layoffs of employees. In 2001, there were about 2,000 mass layoffs and plant closures which were subject to WARN advance notice requirements and which affected about 660,000 employees.
I also want to add that employees entitled to notice under the WARN Act include managers and supervisors, hourly wage and salaried workers. The WARN Act requires that notice also be given to employees' representatives, that is a labor union, the local chief elected official, that is the mayor, and the state dislocated work.
Are employees unprotected by the WARN Act?
Yes, employees unprotected by the WARN Act include workers participating in strike actions, or workers who have been locked out in a labor dispute. Workers employed on temporary projects or the work facilities of the business who clearly understand the temporary nature of the work when hired. Business partners, consultants, and contract employees assigned to the closing business, but who have a separate employment relationship with another second employer and who are paid by that other second employer, and those business partners, consultants, and contract employees who are self-employed. Regular federal, state, and local government employees.
Great, so are there exceptions to the WARN Act?
The WARN Act is not activated when a covered employer closes a temporary facility or completes a temporary project, and the employees working in the facility or temporary project were hired with a clear understanding that their employment would end with the closing of the work facility. The completion of the project closes a facility or operating unit because of a strike or a worker lockout, and the closing is not intended to evade the purposes of the WARN Act.
The WARN Act also is not activated when the following coverage thresholds are unmet.
If a plant closing or a mass layoff results in fewer than 50 workers losing their jobs at a single employment site.
If 50 to 499 workers lose their jobs and that number is less than 33% of the employer's total active workforce at a single employment site.
If a layoff is for 6 months or less.
If work hours are not reduced 50% in each month of any 6-month period.
What is the penalty for violating the WARN Act?
An employer who violates the WARN provisions is liable to each employee for an amount equal to back pay and benefits for the period of the violation, up to 60 days. His may be reduced by the period of any notice that was given and any voluntary payments that the employer made to the employee, sometimes referred to as pay in lieu of notice.
U.S. District Courts enforce WARN requirements. Workers, representatives of employees, and units of local government may bring individual or class action suits.
The court may allow reasonable attorney's fees as part of any final judgment. The U.S. Department of Labor, DOL, is responsible to educate and inform employers and employees about WARN, and to provide assistance in understanding the regulations, but is not responsible for enforcing WARN.
See, we all are one when it comes to national interest, and today's debate was awesome. Thanks everyone. If you like this debate, share this YouTube video to your friends and colleagues.